For my presentation today, it's kind of hard to see. I did it on notepads. I chose Arizona versus Gant. 556 US 332, 2009. Rodney Gant was arrested on a warrant for driving with suspended license. After his arrest, he was placed in cuffs. He was placed in the back of a patrol car. His vehicle was searched after the arrest, and the officers who searched the car found a gun and some cocaine, a plastic bag of cocaine. This is all search incident to his arrest. Gant asked the trial court to suppress evidence, saying the car was searched without a warrant, and this violated his Fourth Amendment right against unreasonable search and seizure. The trial court judge denied his petition, stating the search was a result of Gant's arrest. The trial result was a conviction on 2 counts of cocaine possession. That was the trial court. Gant appealed, and the Arizona Court of Appeals reversed the ruling. They stated that the search was unconstitutional, that the officers did. The state then appealed that ruling. They appealed to the Arizona Supreme Court. And the Arizona Supreme Court affirmed the Court of Appeals ruling, and they added an exception to the Fourth Amendment warrant requirement must be demonstrated by an overwhelming concern for officer safety and evidence preservation at the time of the arrest. That was their ruling. Well, that didn't sit well. The Arizona Supreme Court again stated also, because Gant left the vehicle voluntarily. It wasn't taken from he left the vehicle. The search did not relate to the arrest and thus violated his Fourth Amendment. That's what the Arizona Supreme Court ruled on this. So, the Arizona Attorney General, his name was Terry Goddard, he then sought, I think it's called certiorari, I'm not real good with it, from the U.S. Supreme Court, arguing that the Arizona Supreme Court ruling was an indirect conflict with court precedents along with other various federal and state courts rulings. So we all understand that a precedent is based off a ruling the court and any other court in that area or across the United States has made that kind of directs others what they can and can't do, like in law enforcement, other trials, procedures, and so forth. So, after that one, the U.S. Supreme Court granted certiorari and heard the arguments on October 7th, 2008. They issued their ruling on April 21st, 2009, and the arguments before the court when they went to court. The officers were operating within the ruling precedent, and the Attorney General was using New York v. Belton as one of the cases he was citing. And in that deal, the ruling is basically you can search a vehicle and instant arrest of a suspect. We all use that, still use today. The circumstances were unique to the offense. Justify the search after an arrest when it's reasonable to believe the offense might be in the vehicle. And that is, if they've created an offense, and what he's saying is, if we're arresting him and it's a drug offense, or in this case, he was driving, there may be ID, there may be belongings of his in the vehicle, we can show he was in the vehicle. That's what he's saying. So, after all the arguments, the court gave their ruling, and Justice Stevens, he wrote the opinion for the court. They held that the police may search a vehicle incident to the arrest of its recent occupants, and this is done without a warrant. He agreed that they can, based off the previous precedent rulings that had been talked about before the court. Justice Scalia concurred on the opinion and added that a search of vehicle incident to arrest is reasonable. It is. But he added, only when the evidence search is to the crime for which the arrest was made or another crime the officer may have probable cause to believe has occurred. So, if you're dealing with somebody who's a known dealer in your area and so forth, what he's saying is, if you're arresting for one thing, like such as this guy driving and suspended a license, but you've dealt with him in the past, or the agency has, and he is a known drug trafficker or something like that, you can search because there may be evidence to that if it's known in your area. And you also asked us to cover, do we believe it, this was correct. And I believe the Supreme Court ruling on this was 100% correct. I believe that the trial court was 100% correct on this. You can search a vehicle incident to arrest. You're looking for, like I said, we always look for evidence of that crime. We're always looking for dangerous weapons because we're going to be impounding this vehicle. So you always search the vehicle incident to arrest. And there's also, the inventory deal you can do if there's other extenuating circumstances in that. Upon the arrest, the officer must always be allowed to search. I mean, that's just my opinion. It's got to be. Like I said, this gets uncovering evidence of that crime, other crimes. It's always used to. There's been case precedents set where the search has led to other evidence. It even helped crack a cold case. It's amazing what all we can get from these. So, my closing in this is this is correct. They got this all correct. The officer saw him commit the crime. They searched the car. They were covered by legal precedent, and that is still correct today. This concludes my presentation. I hope you enjoy. Thank you.